Hi everybody. Today we're going to do a Q&A about CPS investigations. Basically the basics in regards to how the cases sometimes are initiated as well as how they are proceeded. Sometimes people are really shocked as to how CPS cases can proceed and the changes between county and county, worker and worker, but there are a couple things that remain the same throughout. Now, a CPS case can be initiated a couple ways. It can be initiated by a hospital if they believe they see signs of abuse. It can be initiated by a call from a teacher as well as a call from someone else who's considered a mandatory reporter. Now, what mandatory reporters are, they are individuals who, as part of their job, are required to contact DHHS, which is the Department of Human and Health Services, and the Division of Child Protective Services. Mandatory reporters are if they see something, bruises on a child, some type of action from a child, something they see inappropriate by a parent or someone with a child, that then they can report those things. Those are included in psychiatrists, nurses, doctors, child care providers, teachers. Those individuals are mandatory reporters, and in and of itself, DHHS workers as well. So what happens with a case is that sometimes a child is taken to the hospital and a doctor believes that the injury that a parent is claiming may not necessarily have happened as they say that it did. So the doctor may either question the child alone or may question the child with the nurse or call a social worker to speak to the child outside of the view of the parent. When they do that, they're and it does depend on the age of the child sometimes, but they will inquire as to what really happened. How did the child feel about going home? How does the child feel about their parent? And what really happened to them that brought them to the hospital. Now, sometimes it truly is just an accident that requires a child to be taken to the hospital, whether they've fallen from playing or whether or not they were doing something and they weren't supposed to be doing it, or innocent accidents. If a child goes to the hospital, then the doctor is required to inquire as to whether or not that injury is potentially a result of child abuse. If they believe that injury to be a result of child abuse, sometimes they will call in the social worker or just pull in a nurse. And sometimes they order full body scans of the child's skeletons to see if there are any healing broken bones. And then they will take a report from there. Usually when the hospital initiates this type of review, a 24-hour on-call worker, CPS worker, will come to the hospital and also begin an investigation at that time. And this is whether or not it's a parent that takes the child to the hospital or someone else that takes the child to the hospital. Once the CPS worker arrives, they will begin their own investigation. They will speak to the adult that brought the child in. They will also speak to the child themselves and begin to compile a report. They will ask the doctor, what did the doctor see? They will look and see if they see any bruises. They will look and see if they see any odd scratches or anything in an interesting place that may not seem like it should be there. And they will start an investigation that way. Now, when you have a CPS case that is begun by a phone call, and that is considered an anonymous CPS case, what will happen at that time is CPS will do an intake. If it is an emergency situation, they will do it within 24 hours. What that means is they believe the child is at great risk of harm based upon what they've been told by the anonymous caller. If the child is in the custody of the parent, they will make a contact with the parent and go to the home and try to speak with the parent as well as try to speak to the child. And this is going to depend on how old the child is. CPS will ask to do a brief home study because they've been called regarding potential abuse. When CPS does that, now you can object, and you have that right. You have the right to tell them to come back with a warrant. You have the right to tell them to file a petition. But please know that CPS will do those things if they believe a child to be in harm's way. Now, if they don't believe that it's an emergency situation, instead of CPS coming out right away, there's a level of calls where they will respond within 48 hours. And sometimes that can be something as simple as maybe a vague anonymous call in regards to neglect, or a vague anonymous call as to abuse, but nothing substantial or substantiated thus far, and not a mandatory reporter. When CPS looks into those matters, they will give a call to the parent sometimes initially before coming out to the house, or they will try to contact back the reporter and see if there's any additional information. And sometimes they will attempt to speak to the child in school without the parent knowing. In doing that type of situation, CPS will go to the classroom. Well, they'll go to the principal or assistant principal, advise that they are there as a result of a report in regards to a child. And they will ask to speak to that child. Usually this will be accommodated by most schools as they are themselves mandatory reporters, and the child will be spoken to alone or can be spoken to with the principal present as well. In doing so, they will ask questions in regards to how does the child feel, what happened, and will try to address what they were told in regards to the anonymous call. Now, when that anonymous call comes through and they have this specific information, they can now, let me clarify, they can only go to the school if they know where the child goes to school. And usually that's a scenario where the mandatory reporter, the school, has said that, has made the call, or the parent or child is already in the DHS system, whether it's from a previous case or whether it is from an initial call that didn't go anywhere, but they may already have that information. So they will go to the school if they have that information. If they don't have the information, the first line of response is the parent, and that is whether the parent is the abuser or even if the parent is just the caregiver. Now, you have some situations where CPS is frequently called in custody matters. And when that is the case, CPS looks at things a little bit more carefully in regards to who is reporting that abuse. Because the purpose for CPS is to ensure child safety, not to just be used in a custody matter or custody dispute. Now, when CPS begins these investigations, if they have reason to believe that the child is at risk of harm, they may ask for what's called a safety plan. Now, sometimes, even if they don't think the child is at risk, but just so that they can do their investigation, they will do a safety plan. Now, they will always tell a parent that it is voluntary. Please know that if they tell you that it's voluntary, it is not necessarily voluntary. And that, unfortunately, is where some parents get caught up. CPS tells you it's voluntary so that they can begin an investigation that should be done within 30 days. However, please know that if you do not agree to a safety plan, you do not agree to placement of your child with a family member or the other parent, CPS will and most likely go to the court and request a petition to have your child removed. They will do that if they believe there's risk of child abuse, drug abuse, and significant neglect. Even if they believe that just to do their investigation is best to have the child out of the home, they may file a petition to do so. Now, that doesn't mean that the petition always states sufficient information for a petition to be granted. That is essentially saying that we believe this child should be removed so we can investigate. Now, this takes us a little earlier to the petition discussion, but it's a very relevant matter, and a lot of parents waive their rights to have the petition heard, and that is sometimes one of the most critical parts in the case to fight the CPS petition. Now, a CPS petition is filed with the court and the juvenile court system, which is the division of the family court system. The petition is supposed to lay out the specificity of everything they believe to have occurred or possibly occurred, and why they believe it satisfies probable cause to have your child removed or child removed from your care. Now, for the petition, that is what the burden is, and that's what the standard is. And a lot of petitions have a lot of information, but they don't always necessarily fit the standard or the burden of proof. Now, burden of proof is a low one in the initiation of a CPS case, like the initiation of a felony case. It's probable cause. Is there enough probable cause? Meaning, did this enough probably happen or occur for us to have this petition accepted by the court to have your children removed? Now, CPS can list everything under the sun in this petition. They can list if you have a history of drug problems, if you have a criminal history for certain things, if there's been a previous CPS call, if it was a mandatory reporter by the hospital, even though there may not have been a broken bone or something like that, or they let the child go home in your care. If you're a father and they don't see sufficient child support history or payments, they may list you as abandonment and that you abandoned your child. They may also do the same for mothers. If your child lives with a grandparent or someone else, they may list you as abandoned and also make you a respondent in that petition. Now, that doesn't mean that all of those allegations are true. What they're saying to the court is we have probable cause that proves all of these things. Now, in this very initial stage of the petition and the filing, there are categories for CPS cases for petitions. They range from 1 to 5. 1 is the worst, which is almost like an automatic termination to have your parental rights taken away, to a 5. A 5 is nothing. It's as if they were called, they came out, nothing was founded, they didn't look in, there wasn't much to be determined, and they let it go. A 4, and that 5 also is unsubstantiated generally. A 4, maybe there was some information there that needed to be looked into. Maybe they gave the parent a parenting class because maybe there was a spanking and CPS believed it to be a little excessive. But instead of filing a full petition, they just filed to have your child, to have you complete a parenting class or something like that. And then they closed the case. Or no real case was truly there. Then there's a 3. A level 3 is substantiation, meaning they believe they have a substantiated CPS claim. So they believe that there are bruises on the child that came from potential spanking or abuse. There are signs, from a doctor or something that substantiate abuse. There are significant enough contacts, repeated contacts, that they believe substantiate abuse. And that's a level 3. Now, a petition can be filed in a level 3, but it's not mandatory. It means that they can they will likely set a family team meeting They will put a family case plan to action. They will ask the parents to complete certain acts. And then if the parents don't do that, they usually follow through with a petition. And then request that the children are removed that way. Now, a level two is when there has definitely been significant substantiation for a claim. Whether it is a repeated extensive spankings that's causing marks or leaving bruises on a child. Whether there are late instances to school in regards to neglect where a child isn't going to school. There's absences and truancy is falling on the parent. The child is never making it to school. There's been drug raids at the house. And as the drug raids, because drugs are being sold out of the house, they may label that as a 2 as well. And in those cases, a petition is more than likely to be filed, meaning that, generally speaking, I would say 6 out of 10 times the petition is going to be filed in a level 2. And this also may vary depending upon the county. Now, for level 1, those are the most serious claims of abuse, and not just a spanking. We are talking broken bones in an infant. We are talking alleged or substantiated criminal sexual abuse by a parent to a child. A family member in the home to the child, and the parent didn't stop it or was aware of it. We are talking severe abuse where a child has been placed in a hospital. We are talking potential shaken baby syndrome. In these cases, a petition is required. Termination is usually sought. And those are the levels of 1 to 5. 1 being the most egregious, where parental rights will likely be lost, to 5 where it really wasn't much more than just a call out and there was nothing else there. So now why that's important to know is because when it comes down to what's going on in your case, or if someone has called, CPS is asking to come and speak to you about something, it's important to know where they may be taking this and what has occurred to where they can take it. Knowing the appropriate levels and the responses to it can also help you move forward in how you want to handle a potential CPS investigation and possible petition. Now, once those levels have been determined, and we're going to go back to the court, and we're at, I will say, a 3 and up, because with a 3, a petition can still be filed. With a 3 and up, all of those facts that we discussed, all of those allegations we discussed, all of your history is put into the petition, and it is sent to a referee. Now, the referee's initial job is to determine, 1, whether there's enough in this petition to allow the court to remove your children or do what the CPS is asking. The court will also determine that whether or not, if the children should be left in your care, even if the petition is granted. Now, if the petition is granted, depending upon the allegations, and I apologize for all this moving around, helping get my assistant situated this afternoon. Once that petition has been put in, you have the right to argue the validity of that petition at that time and whether or not probable cause has been met. If probable cause has been met, again, sorry guys, we are a regularly practicing office. Sorry about that. Ivy, you want to say hi? Sure. This is one of the wonderful staff members at KF Legal Consulting.
It's the weekend. Sorry, I don't have makeup on.
She is one of our wonderful staff members here. that assists in review of CPS cases and investigating. The assistant Ivy is also a 14-year vet, very proud of that, and we love having her here. So let's move back on to the petitions. Now, when the petition is filed, you have your initial hearing. Now, at this time, sometimes you may know it's already coming, and you may have retained counsel. Unfortunately, most people do not have retained counsel and have court-appointed counsel. And the only reason I say unfortunately is because a lot of times in these cases, it is important to begin investigation, preparation, and document review and request prior to that initial court hearing. At that initial court hearing, you have the right to hold the hearing, question the witnesses, and also have DHS question those witnesses to argue against that probable cause. Now, because the burden is very low, that doesn't mean that everything is guaranteed to be bound over to a judge or another referee, or the petition is to be upheld. But what it does mean is that more petitions are likely to get through than to not get through, because it is a very low burden. Now, when we think of burdens, we always hear the burden beyond a reasonable doubt, beyond a reasonable doubt. And yes, beyond a reasonable doubt is true for criminal cases. But criminal cases also start with probable cause as well. Now, once you have the hearing and you've questioned witnesses, CPS has brought in their witnesses. The referee may also question witnesses. And I'm sorry if I'm looking away. I'm just pulling up some additional info for you guys. Even though you've had the opportunity to question and all that's done, the referee may still find that there's probable cause. Now, after that determination of probable cause, the referee will determine from the allegations that's been made whether or not the children should remain in the home under the supervision and care of DHHS, or if the children should be placed somewhere else under the care of DHHS. Now, this is a very fact-specific determination. This is determined by the age of the children. It can be determined by the allegations. It can be determined by the number of children, what the allegation is, whether it's alleged abuse of all, alleged abuse of one, whether or not it's just neglect for education in school, food and clothing, or whether or not this is serious neglect of leaving the children alone, no supervision, leaving them alone very young. And the referee will take all of those things into consideration before determining whether or not your kids can stay home. Now, if your kids are allowed to stay home, services with CPS will begin immediately. The reason is because the court is already finding that there's probable cause that something has happened here. So now, because CPS knows that there are children in the home under their care, they are now under a duty to provide services, maintain and protect those children, even in the care of the parents. They are required to follow up with the children. They are required to follow up with the parents. They are required to follow up with service providers. Now, when I say service providers, what I am specifically referring to is different people that CPS will send to you, or DHS will send to you, to provide therapy, parenting classes, parenting coach, sometimes psych evaluations. It really depends on the nature of the allegations as to what type of services are going to be provided. If you are alleged to have neglected your children as a result of drug abuse, then CPS is likely going to require you to complete drug therapy. And not just drug therapy, but rehab. They're going to require random drug testing. They're going to require also drug therapy outside of just the rehab, and could also require NA meetings as well. So that's what I mean when I say services. And these can begin immediately when if the children are left in the home. Now, if we have an allegation where the children are no longer in the home, they can be placed with, and the referee finds that the children can't remain with you, then what they're going to do is they are going to look and see if there's a family member that can take the children, or if the children have to go to foster care. The court would prefer family. They will look at a non-custodial parent. They will look at grandparents. They will look at aunts, uncles, even sometimes an older sibling. But their preference is always to place the children with family than to place them outside. That's part of the reunification process, because once the child has been removed, and it's not a petition for termination, it is a petition for to make the child a temporary ward of the court, and then reunification goals. Now, when those services begin, whether it is after the petition or with the safety plan per se, it is imperative that you follow through with every request, every action, and that not only do you not just wait around for CPS to advise you, but you also take proactive steps as well. That really speaks very highly, particularly with the court. Now, your children, say we're at the petition stage, the initial, your children are outside of the house. You will get a pretrial date. Now, some counties, they allow that pretrial to occur on the same day. Some counties set another day for that pretrial. On the pretrial date, it will be up to you to decide whether or not you would like to plead to the allegations within the petition and move forward to disposition, or whether or not you would like to take the matter to trial and have a full hearing. Both are your full and complete right. Please know that, and this is one of the reasons that I said it's very important sometimes to have an attorney in the beginning of a CPS case if you can, that your trial hearing is not going to, your trial date is not going to be pushed out that far. The court is not going to give you an extensive period of time to determine where your trial is going and if you're actually going to hold it. And the reason is because they have mandates. They have mandates just like the criminal court has mandates, just like the family court has mandates. Right to, like in a criminal trial, we have right to speedy trial, 180 days. Family court case, there are mandates, particularly in Wayne County, that family cases should be completed and decided within a year. Now, CPS, their general mandate is 60 days. Now, I know you're thinking that's not a lot of time if you need to build a case, if you need to request documents, if you need to retain an attorney, or if you just want to accept court appointed. That is not a lot of time, which is another reason you have to be very proactive as to what you would like to do and how your case is proceeding. You have the right to have the CPS investigation requested. You can request discovery. You can request copies of any records that they have that they're using. You can also have your attorney subpoena records on your behalf. And you can also go to the hospitals if there's any necessary hospital information or documentation that's in your particular case. You can have that requested also and have it used in your hearing. Now, your hearing is what's considered an adjudication hearing. And that's because the burden of proof is different than a criminal case. It is more like a civil case. And what that is by a preponderance of the evidence. Now, if you hear that and you're trying to think, what is by preponderance of the evidence? That essentially means that if the referee or judge determines that it is more than 50% likely that you committed the actions alleged within the petition, then you're essentially found responsible and you've been adjudicated. Now, when that occurs, you have what's called a disposition hearing. And that comes, sometimes it can be done the same day, sometimes it can be done later. Now, with the adjudication hearing, you have the right to call witnesses. You have the right to question witnesses brought by the people. You have the right to present evidence and exhibits and documents. Your client has a right to testify or not testify. All of these things are done at the adjudication hearing. Now, also know that there won't just be yourself and a CPS worker. There's going to be either an attorney general or a county prosecutor working to represent CPS, just as an attorney will work to represent you. There will be what's called a GAL. A GAL is what's called a guardian ad litem. That is someone who is charged with investigating the case on their own behalf, presenting report to the court from what they found, and assisting the court in determining what is in the best interest of the child. The GAL can question the witnesses as well. The GAL can cross-examine and move forward in the case, and their sole goal is to consider and determine what is in the best interest of the children. Now, sometimes the GAL is on DHS's side, sometimes they're on the parent's side, but they should always be on the children's side. They should never be placing the DHS or what DHS says, the parent, and just what the parent says above what's in the best interest of the children. The best interests of the children are determining factors, and there is a outline in regards to the law for the best interests of the children. I'll do that one in a later video. Now, once the hearing has been held, if the referee finds that there is not enough evidence to move forward under a preponderance of the evidence, the case is done. If your children are removed, they go back home. If they were never at home, if they were never removed, the case is closed. You get an order stating this matter is closed. If that doesn't go that way and you have to do the disposition, you again prepare for another hearing if it's done at another date and time. At the disposition hearing, what is provided is it's another determination as to where the children child should be placed and what services are going to be implemented by CPS after the adjudication. Now, the services may have already been in place if the children were still at home, but they may add additional services, or they just may require that you continue the services that you were already doing. Then the argument then comes to, where are your children going to be? Now, in some instances of child abuse, the children are still placed outside the home until it can either be left to the discretion of the court or to the discretion of CPS as to when the children are returned. There are 90-day review dates every 3 months to see what type of progress has been made, where the parents are moving, how the parents are moving forward, if there's been any additional allegations, and whether or not the children should be placed home. Sometimes they're also looking still for family members in that time frame, if none have come forward as of yet, to place them with a family member. During the review period, you will be visited by the various workers. You will have classes to complete. And you will also have GAL visits if your child is left at home with you. GAL visits are usually only one before the next hearing. They're required to do an intake of the children before the next hearing. But sometimes they do it very early on and don't do it again. Sometimes they do it later, right before the hearing. It is really kind of up to the GAL when that's done, unfortunately. Now, but here's another thing. And I don't even know if all counsel are aware of this or if all individuals are aware of this, is that when the GAL makes their report to the court at that review, and when DHS make their report to the court, you also have the right to make your own report. You can present your own memorandum. Your attorney can, or you can, to be reviewed by the court that's in your favor. Because you can't trust that CPS is going to give them everything that is beneficial for you. You can't trust that CPS has done all of their due diligence to make sure that adequate information is provided to determine what's in the best interest of the children. Sometimes CPS does their investigation early, they do their report early, and then other things happen that the court is never apprised of. And you may think to yourself, oh, well, we can just tell the judge when we go. You can also say, oh, well, my attorney knows, I'm sure he'll just do it. Please don't make those assumptions. You must be very proactive in CPS cases. Now, when I say present memorandum or documents for your own review, what I mean is putting together information such as certificates of completion for your CPS classes, certificates of completion from your parenting class, letters in your favor that you've completed a certain number of counseling sessions, documents from drug testing, because what if they missed a test? What if they did not adequately obtain it? What if you tested a little bit later in the day and they only sought records from that morning? Then again, that is information that's in your best interest that is not being presented and the court may not otherwise be apprised of. Now, another thing that's to keep in mind when you're at this review stage is that you have the right to request, and you have this right even before this time, what's called as a family team meeting. A family team meeting is where you sit down with the CPS investigator. You sit down with possibly a foster care worker if the children are not placed at home. You may sit down with the supervisor of the CPS worker and the parents, yourself or whomever is caring for the children, and then you have a right to discuss all the issues that are present, all your concerns, anything that's come across, anything that's been raised. Answer questions, ask questions. This is essentially your time to get out your own concerns to CPS and even what's been occurring with CPS. If you feel that your worker is not adequately supervising the children when they're not in your care, if you feel that there's been some significant changes with whether or not with your child's education, if you feel that you haven't been getting your services, which is a number one complaint that I have seen in a lot of cases, particularly when the children are not at home. When the children are not at home, services take a lot longer to begin. The reason is because DHHS and CPS use contracted third parties that they send referrals to. They send the referrals like outsourced to all of these different contacts. They send them to state therapists if the person doesn't have insurance or required to go to state therapists. They send them to the drug testing. They send, to the parenting coach. They send them to outside family counselors. They send all of these things out for referrals, and then essentially just wait. Now, if you have a very proactive worker, then you're lucky, because then they're assuring, or they're likely assuring, that you're going to get your services in a timely manner. They're going to follow up on the referrals. They're going to look into the referrals. But here's the next thing, and this is, again, where being proactive really comes into play. If you are not getting your services, you need to tell your attorney so that your attorney can file a show cause, can file a motion, can bring the issue in front of the court and say, Your Honor, we have strict 90-day reviews. We're required to have services. Referrals shouldn't take longer than 30 days to begin, and actually should have begun sooner. if there's a plea in a case, because you already know that the parent is pleading. So certain services should already be in line, whether it's therapists for the children, therapists for the parents, drug testing, all of those things should already be wheels in motion when the case begins. There is no reason that services should not be started in a timely manner. And that is where a lot of parents get caught up in the system for an extended period of time, because there are things that they believe are outside of their control, and they are to a degree, but because they're waiting on CPS to tell them what to do. Now, if your services have begun and you are moving forward and you come to your review, a couple things could occur. Now, if there are no new allegations, no changes, anything like everything's been positive, you've completed your parenting class, you've had your parenting coach if necessary, you've completed family counseling, you're in therapy, you're doing all of those things. At this initial review date, you may have your children placed back home. Now, that doesn't mean that DHS they still are not in the care of DHS. But what that does mean is that DHS is just going to follow up with your children while they live with you. They are going to do pop-ups. They're going to pop up at the school. The GAL may do a little bit more visiting. But you have your kids home at this point. So, and they're following through. If your children are not returned home, it could be a couple reasons. Maybe there are still extensive services that need to be completed. Maybe the children are not in the services as they're required to be in, because sometimes the children are required to have very specific services themselves, particularly if there are allegations of abuse, physical abuse. They may have their own therapy that they need to begin before they can come home. Now, if that's the case, you'll get another review date. And you'll get it anyway, but you'll get another review date. Now, if for some reason there's a new allegation, maybe it's not as extensive as the first, maybe it's just something they believe may have happened, maybe the child reported it, maybe the person the child is living with reported it. And when that happens, they will start a new investigation on that new allegation, and it will delay your new case. Your current case. If your children were about to be placed back in the house, they are not if there's a new allegation. Sometimes they won't even be placed back home if the case is unsubstantiated. They still may not return the children home. And not because the court necessarily believes that it happened. That could just be one of the reasons. But the court may not return the children because they may either feel after investigation, maybe the parent is lying, maybe the reporter is lying, maybe the child is lying. And those are a lot of concerns that can be raised, but the court may not initially be able to determine the validity of that, especially if a case is going on. So they're going to take a rather be safe than sorry approach. They're going to rather keep the kids out of the house. They're going to rather allow the investigation to occur. And they're going to set a new review date. And when they set the new review date, it will be another 90-day period for which you may have new services to begin, continuation of your older services, and time to allow that allegation to be investigated. Now, sometimes new allegations go completely unsubstantiated and they've delayed a case unnecessarily. But again, safe than sorry approach. If there is a new finding, please know that CPS can file a new petition. They may also request to amend their petition depending upon the allegation. If the allegation is another abuse allegation, physical, sexual abuse, mental abuse, and they will do it for mental abuse, extreme neglect, they may not just file another petition on the case to keep the children out. they may file or amend the petition to termination, depending upon that allegation, because they're going to look at it like, we've given you these services, we've given you these classes, we've given you all of this information, and you are still allegedly committing these acts. Now, you still have the right to question the new petition. You have the right to challenge new allegations, but they still will delay your ongoing case. And you will have two. And there's no guarantee that the new allegation will run as smoothly as the second. Now, if that alleged abuse, say it happened in a family member's house, well, now the child or children are going to be removed from the family member and placed in foster care. They will have a foster worker. There will be foster guidelines, and your visitation may be cut down. Now, that was one thing we hadn't discussed yet in the cases. We've gone through the timeline from the safety plan to the petition, to services, adjudication hearing, disposition hearing, and reviews. Now, during this time frame, throughout this entire process, visitation may or may not be allowed depending upon the allegation. So if you have a temporary ward case, which is where they're seeking reunification, which is the most common case, you will likely begin with supervised visits. Not necessarily at a facility. And again, this is if the children are not in the home. If the children are not at home, you may be allowed supervised visits with an approved supervisor, where CPS may approve family members to be supervisors. They may approve other individuals to be supervisors. And sometimes you have an unlimited amount of time, and the time is only based upon time constraints of the supervisor for visitation. And that also will sometimes depend upon the age of the child. Now, if you have one of the more serious allegations, then you will have supervised visits at a facility or at a third-party location with the supervisor. Those are generally time constrained to 2 to 3 hours. If you have even more serious case, you will have parenting time, 1 to 2 hours a week. Supervision 1 to 2 hours a week at a predetermined location, which is either going to be the foster care facility or a DHHS facility, where you will see your child supervised with either your worker, possibly a parenting coach, possibly the children's therapist, depending upon the allegations, for about 2 hours once a week. If you have multiple children and they are not placed together, they will do their best attempts to put the supervised visits together so that you can see all your children at the same time. Unfortunately, that's not always the case. Now, the different levels of supervision are based upon the case and the children. They are based upon the parent and services. They are based upon whether services have begun. And they are also based upon DHH's recommendation as well as the GAL. Now, visitation can change throughout a case. Your children can start out in your home at the very beginning of a case and wind up in supervised visits later. It can also work the complete other way around, where the children are in your home, you're only allowed supervised visits for a specific period of time to straight reunification. Now, when that occurs, you are close to the end of your case, unless something else happens. Now, reunification process, you're given a year. You can go beyond that year for extenuating circumstances outside of your control, and it may be extended to about 15 or so months. Extenuating circumstances would be an injury to a parent that is preventing him or her from completing certain services. It could be services weren't started in a timely fashion like they should have been, and that is outside of the parent's control. They could also be certain issues with the minor child that also result in the matter taking an extended period of time. But generally speaking, the reunification goal is a year or less. After a year, you get to what's called the placement area. And now they are looking to determine whether or not they need to terminate your parental rights after a year. They look at whether or not you've been participating, whether or not there's been new allegations, whether or not the original injuries are more extensive than what they originally believed, whether or not additional information has come out from the child, whether or not the parent has just stepped away and completely abandoned attempts to regain, to be reunified with the children. That time, the termination petition will be filed, and then a family member will be sought, if one hasn't already been located, to determine whether or not there should be permanency planning for the child with a family member. Permanency planning is termination of parental rights and adoption of the child to someone else. Adoption can be to a family member. Adoption can also be to someone else. They could be in foster care. They can be adopted in state. They can be adopted out of state. But those are all the things that begin at the permanency planning time frame. Now, that, again, is outside of a parent's control in regards to placement sometimes, especially if the parent hasn't been proactive. They will base a petition on abandonment for termination. If you have been very proactive throughout your entire case, and everything, the actions that are rising to the level of termination outside of your control, then you have your rights to fight. Now, the burden for termination is completely different for a burden for just simple removal. The burden for termination is the highest burden available in anything, and that is by clear and convincing evidence. So let's just say probable cause is here. Preponderance of the evidence is about here. Beyond a reasonable doubt is here. Clear and convincing evidence is here. Basically, it must be unequivocally clear to the court by everything presented that your child should not be with you. And that's determined by the parent's actions throughout the case, the children's throughout the case, the underlying findings of the case, how the case has proceeded. All of those things are determined, are looked into as to whether or not it's completely and unequivocally clear and convincing that the best interests of your children are for you to lose your parental rights. Now, again, that is a very high burden, rather. But some cases it is easily met. And some cases they start off with that at the very beginning. That is the best way to make it clear as to how serious the cases can be. Now, this was just kind of a brief overview of the generalities of CPS cases. They all have their own twists and turns. Sometimes there's a lot more people involved, a lot more family members involved, a lot more fathers and mothers involved. Sometimes the allegations aren't against parents, but against others that are caring for the children, but it still affects the parents. Sometimes cases seem to have no true basis, and you're wondering why you're stuck fighting it. But you must keep in mind, you still have to fight, because if you don't, the worst case scenario is you are no longer the parent of your child. In my office, we handle quite a few CPS cases. They are usually attached with a criminal case, with a custody case, with a divorce case, and sometimes I just receive CPS cases on their own. In our office, we have represented individuals in CPS cases in multiple counties and for multiple reasons. Some abuse, some abandonment, some neglect. Finding that there seems to be an increased number of CPS cases that are coming about. The increased powers that CPS are seeking to enforce, and individuals not knowing their rights was the main or even knowing the process is the main reason I did this video. A lot of people don't understand what they're fighting against and are already at a disadvantage. If you don't know your rights, you don't know how to protect them. If at any time you feel that your rights are being violated by CPS, or you feel as though you don't understand the process, you need representation, you know that, okay, maybe this case is substantiated as to you, but you just want to make sure that everything is being done as it's supposed to, please feel free to contact our office. We are located right downtown in the International Building. Our number is 313-309-9638. We are here to help you if you have questions. Have a good weekend, everyone.